Good morning. Welcome to today's webinar on Dobbs v. Jackson's Women's Health. Our first guest is William Saunders, a human rights lawyer, the director of the program in human rights at the Institute of Human Ecology at Catholic University, and the co-director of the Center for Religious Liberty at Columbus Law School at Catholic University. Our second guest is Arina Grossu, the founder and principal at Areté Global Consulting, a fellow of the Center on Human Exceptionalism at the Discovery Institute. She previously worked as a senior communications advisor at the Health and Human Services Office for Civil Rights under the Trump administration, and she was the director of the Center for Human Dignity at the Family Research Council. I'm your moderator, Phil Cerrone, an associate ethicist at the National Catholic Bioethics Center, and Sarah Czar, the NCBC's membership director, will be helping moderate questions at the end of the panel. So in Dobbs v. Jackson's Women's Health, the Supreme Court overturned Roe v. Wade and Planned Parenthood v. Casey, ending a 50-year federal right to abortion. Since the court's decision was released, commentators across the political spectrum have broadly discussed the potential implications of this decision. Today, we're going to closely examine the opinion in Dobbs to unpack the majority's rationale for why abortion is not guaranteed by the Constitution. We're also going to look at what Dobbs realistically could mean for state and federal law and what the pro-life movement should be focusing on next. We're going to start with Bill Saunders for some legal background and an explanation of the decision. Bill?
Hey, good morning, everybody. I assume generally you're folks that are very conversant in this issue, but I will not assume that you're any as conversant as I, as a lawyer, have had to be in all this. But so I'll make it accessible, I hope, and clear to non-lawyers, and I'm happy to answer your questions at the end. But I don't, as they say, I don't want to bury the lead. The lead is, this is the greatest day for pro-life Americans in my lifetime. You know, we've all worked for 50 years to overturn Roe v. Wade. I mean, I'm in Washington, D.C., and I go to the March for Life every year. And again, I'm a human rights lawyer, and I think it's the most impressive continuous human rights endeavor in the whole world, and people come from around the world and they've seen it. So this is a big day. Whatever challenges we still have, this is a gigantic day. In fact, I think it's interesting we're doing this broadcast on the week of the 4th of July because it's a big day for you as an American citizen. What this opinion means, in a sense, is it's your Independence Day. You have your vote returned to you. You are no longer disenfranchised. You get from now on to vote on this issue and to make a difference by trying to persuade your neighbors about the wisdom of building a pro-life America. And this day, of course, follows what John Paul II challenged us all to do, which is build a culture of life. But we couldn't do that unless we reversed Roe and Casey. I also want you to be aware that around the whole world, people are watching this. I'm involved in a number of international organizations, and I have been told by people how much they're looking for this decision. You might think, well, this is just the US Supreme Court, and technically that's true. It's just the court of the United States, but around the world, it has a huge impact. So this decision, reversing this 50 years of a horrible decision, is very, very important for pro-life efforts all around the world. So I want to give you 2 minutes about the state of American law before, well, actually, I want to do one other thing first. I want you to remember this, because we can talk about it more in the questions, but this is the triumph of practical politics. I'm an academic, but it's not about academic thinking about this, that, or the other. It's about practical politics. It is necessary to elect people who understand the proper judicial role in this country. And we have done that, and we have people on the Supreme Court who are called originalists. Now, this is a document from the Federalist Society called The Great Debate. And this was initiated when Ronald Reagan became president and Ed Meese was Attorney General. And they started a debate about what's the proper type of interpretation of the Constitution of the United States. And the doctrine you may have heard of is originalism. And it says, apply the Constitution as written, not as what you think it should be or what it might mean today that it didn't mean back then, but what does it mean? What do the words mean? And we have on the court now at least 5 originalist justices. And it's only because of practical politics. I want to emphasize, without practical politics, this day would never, in my opinion, never have come. So everything you did to elect pro-life people who would appoint and confirm pro-life justices, that's what we're calling them, but I would say originalist justices, because they apply the Constitution and the Constitution does not mention abortion, has come to fruition. The other thing I want to mention is this is, and I just mentioned this is a book I did called Unborn Human Life and Fundamental Rights. And the reason I mention it is my first chapter in this book is the state of American law before Dobbs. And I assume most of you know this, but I want to emphasize it for you. In America, you could get an abortion at any time for any reason. At any time for any reason. Again, at any time for any reason. That is the most extreme abortion regime in the whole wide world. Most Americans don't realize that. I imagine you do, but maybe some of you don't. And it's because of Roe and its companion case called Doe v. Bolton. You could get an abortion anytime for any reason. I was on a brief in the Supreme Court in the Dobbs case, and we pointed out how around the world most nations severely limit or prohibit abortion once you get to about 12 weeks. And therefore, even what Mississippi was doing was not radically restrictive. So what happened in Dobbs? And by the way, I was overseas when Dobbs was announced. And it was a thrilling day because I had to teach students the next day about human rights and international law, and also about the American Constitution. So as you probably know by now, it was a 6-3 decision. It overturned Roe and it overturned Casey. There were 5 justices united in a majority opinion, which is extremely important because if you don't have a majority, you don't have an opinion to which legislators and courts can look to clearly set out what the rules are or what the doctrine is. So if it had been if it had been 6, but it had not been it had been a 4-person and a 2-person 6, that would have been very bad. What we had was 5 joined together, plus the Chief Justice concurred, that made 6. And then you had a dissent by 3 of those that are generally called the liberals or the left, urging that Roe and Casey not be overturned. So how did the Supreme Court reach this decision? Well, it carefully, very carefully, the opinion is worth reading if you want the whole, understand the history of this. But first they just looked at Roe and they analyzed whether Roe was a solid decision. Then they looked at Casey. Now I'll just stop and mention, I'm sure you know all these cases. Roe v. Wade was a 7-2 decision. and it found a right to abortion, and in a very strange way. It didn't deeply root abortion in any particular provision of the Constitution. It seemed to root it in a privacy right which was implied. Then that was 1973. So in 1992, Planned Parenthood v. Casey was the next case that considered whether or not to overturn Roe. And you may not know this, it's very important. In 1992, Roe would have been overturned if one of three justices appointed by Republican presidents and it's thought to be pro-life had voted to do so, because you had four justices who were willing to overturn Roe in 1992, and you only need a total of 5 votes, right? It's a Supreme Court's 9 members. If you get 5 votes, you've got a majority, and you write that sets the opinion. But the reason Roe was not overturned in Casey was because these 3 Republican appointees joined two hangovers from the Roe court and upheld Roe 5 votes to 4. But they didn't all join together. So there wasn't a single 5-vote opinion. The 3 Republicans wrote something that we call the plurality decision, because whichever way they went, if they went with the 4 dissenters, Roe was overturned. If they went with the 2 who wanted to uphold Roe, Roe was upheld, but they didn't join us why Roe should be upheld. And so in Casey, they said we're going to uphold Roe, those 3 said we're going to uphold Roe because of stare decisis. And that means the principle that you respect an opinion that has been decided previously. But they actually completely redid the standards that had been set forth in Roe, and a completely new test that was called a substantial burden test, which is if the restriction had a substantial burden on a woman choosing an abortion, it would be struck down. A very vague standard, which the Supreme Court pointed out in Dobbs, is an unusable standard, and it shows in parts of the opinion how the appellate courts have never figured out how to apply this substantial burden standard. But anyway, in both Roe and Casey, the emphasis was on viability. You could not prohibit any abortions before viability. So that brings us to the Mississippi statute, which was the issue in the Dobbs case. And Mississippi prohibited abortions after 15 weeks. Viability is an imprecise term, but it's understood to be somewhere 22 to 24 weeks now. It wasn't back when Roe was decided. It wasn't that when Casey was decided, but better technology and better medical care makes viability the time the fetus can live outside the mother. It moves that time period back. But in any case, let's assume it's 22 weeks. That's still 7 weeks after the prohibition in Mississippi. So the issue before the Supreme Court is, can a state prohibit abortion before viability? And the Supreme Court had to decide, therefore, whether to uphold Roe and Casey, which said no abortions could be prohibited before viability. So the court overturned both of them. The court said, I'm reading this from the opinion, the Constitution makes no reference to abortion. And this is what I'm about to say now is very important. And no such right is implicitly protected by any constitutional provision, including the 14th Amendment's due process clause. So according to the Supreme Court, majority of 5 concurred in by the chief, no such right is implicitly protected by any constitutional provision, including the 14th Amendment. So 1 minute on the 14th Amendment, because there's no reason to think that you, if you're not a lawyer, you've even read it lately, but the 14th Amendment basically says, no one shall be deprived of life, liberty, or property without due process of law. That's in the 14th Amendment. That was adopted in 1868 after the Civil War. And subsequently, the courts have decided that sometimes it's their job to determine whether an asserted right falls within that 14th Amendment. Because listen, when I say that again, no one shall be deprived of life, liberty, or property. So it doesn't mention anything specifically, but it uses the word liberty, it uses the word property. And in Planned Parenthood v. Casey, the Supreme Court took that abortion right, which was vaguely found under privacy in Roe, and put it squarely in liberty under this part of the 14th Amendment. And it defined liberty in a phrase which is infamous among lawyers, but you may not know it, but you may have heard it referred to. Justice Scalia referred to it as the sweet mystery of life passage. Casey said this, quote, "At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life." Now that is an untethered concept. It's as broad can be. And in fact, in Dobbs, the Supreme Court says this definition of liberty may correspond to one of the many understandings of liberty, but it's certainly not ordered liberty. And the court goes on to say the standard in Dobbs by which we determine whether there is an implied right that's not specified in the Constitution is we ask the following question: is it part of the history and traditions of this country and implicit in the concept of ordered liberty? So the Supreme Court said in this case, whatever that definition of liberty means, that it can't be ordered liberty because there's no limits on it. So very importantly, the Supreme Court has destroyed this idea that that definition of liberty can be used by the courts to protect things that are not mentioned in the Constitution. And the reason that's essential is because that was first raised by the Supreme Court and Chief Justice Rehnquist in the Glucksberg opinion in 1995, I believe, which found there was no right to assisted suicide. So Planned Parenthood v. Casey had this very broad liberty definition in 92, but even a few years later, you would say, well, doesn't that give you a right to assisted suicide? The Supreme Court said, no, you got to find rights in the nation's history and traditions and implicit to ordered liberty. And so this kind of tension in the law has now been resolved. If you're going to imply a right that is not specified in the Constitution, under the 14th Amendment, it has to be based in the nation's history and traditions. And the court clearly shows that in 1868, 3/4 of the states criminalized abortion at all stages. No state constitution recognized the right to abortion. So there's no possibility of saying abortion was a recognized right in American history. And therefore, it overturned Roe and it overturned Casey. I want to say just one thing and then I'll turn it over to Arina. The critical, practical question is, okay, we now know that there's no right to abortion in the Constitution. Remember, it's not implicitly protected by any constitutional provision. including the 14th Amendment. So what if somebody, that means the issue then goes back to the states, right? Because this means there's no constitutional right, but the states can then make the law where the federal government does not preempt them. So let's say a state does pass some kinds of restrictions. How are we going to, say you take a state, and say state X, and it's not a pro-life state, but it's not a completely pro-abortion state, and it passes some restrictions on abortion. How are we going to determine whether the state can do that? And it's important for legislatures and voters in that state to determine that. This is so important. The court said that will be judged by the rational basis test. The rational basis test, not substantial burden test. Rational basis is the way the courts look at all legislation. So if we have a legislation on, I don't know, some environmental issue wherever you live, and it's challenged, is it constitutional? The court looks at, is there a rational basis for the way the legislature acted? If there is a rational basis for the way the legislature acted, then the court will uphold it, and it defers to the legislature. We're also used to what it's been doing with abortion for 50 years, which is the opposite of this. It never defers to the legislature. It has a substantial burden nobody tests, nobody can figure out, and it decides everything itself. Now it's completely changed. The legislatures get to decide, and if there's a rational basis, it'll be upheld. And I just want to read you this paragraph, and then I'll turn it over. These legitimate rational interests for the preservation of prenatal life, the legitimate interest in the rational basis that would be, the court's given examples of things that would be upheld. Respect for and preservation of prenatal life, protection of maternal health and safety, elimination of particularly gruesome or barbaric medical procedures, the preservation of the integrity of the medical profession, the mitigation of fetal pain, the preservation, the prevention of any kind of discrimination on the basis of race, sex, or disability. If any of those are just examples, but if a legislature on the basis of legislative findings and reflected in the law passes restrictions on abortions in a state that does not guarantee life in all stages, the court is saying it'll be upheld. It is a new day, and there's really no limit on what you can do. Okay, I'll wait for questions for the rest. Arina,
thank you very much, Bill. That was very, very helpful, very interesting. And now we're going to turn it over to Arina Grossu to talk about, what are the next steps? What's going to be happening?
Thank you, Phil, and thank you, Bill, for such a great summary. Thank you all for being on this webcast. As Bill mentioned, this is an incredible time in the movement that cannot be overstated at all. The fact that we've been working at overturning Roe for almost 50 years, the fact that now nearly 1 million babies, I think it's around 800,000 babies, will not be killed. Obviously, there will be some states that will continue to do abortions, and there will be people who will cross state lines, but the number will drop significantly. So this decision impacts lives in a very significant way. Before I go into what has already happened in the states, and actually what will happen also in the next couple months, again, I wanted to reiterate what Bill said, which is, so the central holding in the Dobbs case is that the Constitution does not confer a right to abortion. Essentially, it will go back to the states as it has, and each state, through their elected representatives, will decide what will happen in their state. Now, again, we would not have had Dobbs if it was not for the justices that were appointed under the Trump administration. And I think that also needs to be stated, that elections matter, and it has made a huge difference in the pro-life movement. Before the Dobbs decision and before Roe was overruled, the U.S. was an outlier in the world. It was one of 7 countries that allowed abortion until the day of birth, and it joined countries such as North Korea, China, and Vietnam, and so it was really, really far out there. Although there were different states had different gestational limits on abortion, some did not. So let's see what happened since the Roe ruling. Within a day or two, within hours, some of the states went back to their pre-Roe bans. So I'll explain that the states that right now have pro-life laws, they generally fall into 2 different categories. The first are states that had pre-Roe bans that were, in a sense, superseded by the Roe decision. So once Roe was overruled, the pre-Roe bans that banned abortion, prohibited abortion in those states went into effect right away. The other set of laws are newer laws that were passed in anticipation for an overruling of Roe. And those are sometimes called trigger laws, although I would prefer to use the word conditional laws. They were conditional upon Roe being overruled. So once Roe was overruled, they went into effect. As of today, there are 10 states where abortion is now prohibited. And that includes Arkansas, Alabama, Kentucky, Louisiana, Missouri, Oklahoma, South Dakota, Texas, Utah, and as of yesterday/today, Mississippi is closing its last abortion facility, although it will be moving a facility to New Mexico, where abortion is still legal. The point to make is, obviously, Roe did not make abortion illegal in the US. It just sent that decision back to the states for them to work out through their own state process.
Dobbs.
And
Arina.
yep.
You said Roe, but you meant Dobbs.
Dobbs. And in an additional 7 states, there will be more pro-life protections coming very soon. So some of the states in the laws that they passed, they said within 30 days of the decision that these laws will go into effect. So those states include Florida, Idaho, Ohio, North Dakota, South Carolina, Tennessee, and Wyoming. Also, some of these, so for example, some of these states had heartbeat bills that were enjoined because of Roe, and those are now also being looked at. So for example, in Georgia, the courts are in the process of determining in the next few weeks if their heartbeat law will take effect. So we will see this kind of influx right now of different decisions in different states, and I'm following them closely, because what we will have to do is, obviously, in the states that right now protect life, we will also have to focus on providing for women and children in those states, and I will go a little bit more into what we should do on that front. But also, I think in the states that are clearly pro-abortion states, they will become, sadly, tourism states for abortion. California, New York, New Mexico, Colorado, other such states. And I think in those states, what our strategy should be, in the states that still will allow abortion, is to at least have cities that are sanctuary cities that protect against abortion. So we could start city by city in those states that are still pro-abortion, and at least do that. Obviously, we have nearly 3,000 pregnancy resource centers around the country. And as you can imagine, those pregnancy centers will have so many more women coming there. They need our help. So, and it's not just for counseling. If you have that gift, great, but they might need legal help. In fact, right now with some of the threats and violence against pregnancy resource centers, they might need some security help, and you might know of a company or people that can help them in that way. Others will need financial funding or material funding. So doing drives, etc., for these pregnancy resource centers would be very helpful. I would recommend just contacting your local pregnancy centers and asking them directly, what is it that you need right now? And see if you can get those resources for them to come alongside them, because obviously there will be so many more women who will go to them, and these women will definitely be more abortion minded. There was a study, a poll that was done by Heartbeat International, and they found, so in Texas, since September 1st, 2021, their heartbeat law went into effect, which essentially made abortion illegal after 5 or 6 weeks gestation in Texas. And so Texas, since September of last year, has been in a quote unquote post-Roe reality. And the pregnancy resource centers in Texas were experiencing this influx of women, especially more angry abortion-minded women. And so even the clientele of the pregnancy resource centers is changing because of the Dobbs decision. You can also go to optionline.org to find the nearest pregnancy resource centers to you to help them. But I also recommend that there are other ways that we need to really step up our game, especially the churches and in our offerings of medical care. So there's been a new trend. So pregnancy resource centers do amazing work, and obviously they provide a lot of resources to women. But what Planned Parenthood has done is to try to make themselves a medical clinic and to provide other services. So people go to Planned Parenthood for other medical services, although they don't really offer that many. We in the pro-life movement have also started medical pro-life centers. And in case you're not familiar with them, there's an organization called Pro Women's Healthcare Centers, PWHC, and they're a consortium of pro-life medical clinics, and they're popping up everywhere. And they offer everything from well woman and gynecologic care to STD testing, breast exams, maternity care, abortion pill reversal, miscarriage support kits, hormone management, fertility education. And they will also offer things such as childbirth classes, adoption services, food housing and referrals, abortion counseling, etc. So they're offering a fuller range of services. And these are the types of things that I believe is a future of pregnancy resource centers in the movement. And some of their affiliated medical clinics are already located in Arizona, California, Colorado, Florida, Iowa, Nebraska, Texas, and Virginia. There's also the Guiding Star Project, which also has 7 medical affiliates in 5 states. And then there's Obria Medical Clinics, which mostly operates in California, although it does have a total of 19 locations, and not just in California. So even though we don't have one central medical clinic, there are different groups starting those. So I think that that's also the future of the pro-life movement, is getting medical clinics set up. Now, I mentioned churches, and in a post-Roe America, I do think we need to activate churches more. And I'm not just talking about Catholic churches, evangelical churches have to do the same. There was a CareNet survey a few years ago that said, that found out that more than 4 in 10 women who have had an abortion were churchgoers when they got the abortion. And that is a stunning piece of information for us to have. And that another poll found that 7 in 10 women who have had an abortion identified as a Christian, including 27% Catholic, 26% Protestant, 15% non-denominational, and 2% Orthodox. And in terms of what we have to change, the way that an abortion-minded woman looks at a church. The poll found that 60% of women who had an abortion received or expected to receive a judgmental or condemning reaction at their local church. And again, that's very sad, because obviously the Catholic Church and a lot of the Protestant churches are pro-life. But if a woman thinks, oh, I can't go to my pastor, I can't go to my priest, or I'm not going to go to one of those Christian churches because they will judge me, that's a problem. And I think this is a place for lay people especially to step in, because as we know, priests are really busy, and some priests have to go do masses at various churches, so there aren't enough priests for even basic sacraments in some locations. And so this is an opportunity for lay people. We can't just put it on the church or the priest to start support groups, but really what women need, especially single women who are pregnant, is someone to accompany them, and not just through the pregnancy, but after. And the church is the perfect place where that accompaniment can happen. If a lay person in a church could say, I want to start a support group for pregnant women at the church, all of a sudden you don't have to have all the material resources. You can send them to the Pregnancy Resource Center to get some of the resources they might need. But in terms of the emotional support, the spiritual support, this is where I think there's no reason why every Catholic church in America shouldn't have a pregnancy support service as part of the church. And it could be led by lay people, volunteers. I think that's what we will need to do to step up and actually show that we do care about these women and their children, and that it's not an either or, it's a both and. We love them both, we care for them both. And I think that's a way to move forward. Another piece of information from these polls is showing that the father of the baby is the main person who influences a woman who's abortion minded. 38% was the number that it came out to, that said that among a woman who had an abortion, that was the most influential person in her abortion decision. 38% was the father of the baby. A medical professional was 26%, and her own mother was 14%. So those are the 3 top people who influence a woman in the abortion decision. So again, it's in a post-Roe America, we're looking at rebuilding the family, because where there's a father involved, and especially a father who is supportive and will be there for the mother, the likelihood not only of her keeping the baby, but obviously children should ideally be raised with a mother and a father. And so what we're seeing right now, almost 50 years later, is here we have the tatters essentially, and we're trying to come back together what was destroyed. And not only was the link between mother and child destroyed with the Roe decision, but the breakdown of the family. And so part of moving forward is to start rebuilding the family. And I'm going to wrap up quickly, because I know that we'll have questions. But in America, this might also be surprising, shows that a Pew Research study of 130 countries show that the US has the world's highest rate of children living in single parent households. And over 80% of those children are living with their mothers. So we have an epidemic of single parenting. So again, there are no easy solutions, but we will see the need even more of bringing back the family. I also want to mention the state of Texas, because they have done an amazing thing for their pregnant women, and every state should follow suit, even the ones that are right now pro-life and don't have any abortion in their states. And that is, Texas increased their abortion alternatives to abortion grant program, and this is state funded. In 2022, they have given over $100 million in grants to not only pregnancy resource centers, but other centers that increase adoption, that help women, children, families to get back on their feet. And so this is a very pro-life thing for each state to do, is to either start or increase their state funding for programs that help mothers, children, and families. And obviously there will be a lot of children being born who otherwise would not have been born. And part of some of the policy changes at the state and federal level that I do think we need to consider is to make adoption more affordable. Obviously with foster care, the costs are a lot cheaper, little to nothing actually in most cases, but private adoptions can run between 20 and 45,000 and can cost up to 70,000. And it's when we will have this influx of children and moms who may not be able to care for their children and want to place them for adoption, we have to help an average American family be able to adopt. So these are just some of the ideas that I present in a post-Roe America, and how to continue building a culture of life and to increase resources. I will end with one more piece. Obviously, just because abortion has now gone back to the states, it does not mean that abortions will not continue, as I mentioned. But another key point that I want to bring up is that chemical abortions are on the rise. And because abortions are prohibited in a number of states, the pro-abortion movement is trying to do whatever it can to get abortion pills to women, no matter where they are. And some of these are coming from other countries. They're not regulated. Women are not miscarrying, but they're having an abortion by themselves in their own houses. And it's a problem. And I'll just end by saying that in 2020, chemical abortions make up 54% of all abortions in the US. So more than half of the abortions in the US are chemical abortions. It was 0% in 2000 and 24% in 2011, 39% in 2017. So it's just increasing. And that is an issue that we need to face as well, that chemical abortions will continue to increase. And we also have to make the abortion pill reversal more accessible to women and promote it to help women who decide after taking the first pill that they actually want to keep their baby. Thank you.
Thank you very much. That was very good, Arina. We have some questions coming in. This first one, is for both of you, and it seems like it's based kind of on a lot of what's been out in the mainstream media right now. But how would you respond to the claim that because abortion was permitted in certain circumstances under common law, that this indicates that some right to an abortion is rooted in our nation's history?
Well, the Supreme Court takes that apart in its opinion. I just think that's inaccurate. You ought to read the Supreme Court opinion. The common law never approved of abortion. It did not punish it every time it occurred. And the court goes through this in detail in the opinion. And Professor John Keown, who the court cites from Georgetown University, has written extensively on it.
Arina, you have anything to add to Bill's response?
Well, we know that abortion, even before 1972, abortions were happening, behind closed doors, etc. We've had abortion since, as long as people have been around, there's been abortion. And even before 1973, some of the states had legalized abortion, California, etc. There is no right to abortion, nowhere in our Constitution. And in fact, as Bill had mentioned in his first portion, the right to abortion, quote unquote, was grounded in a penumbra, the right to privacy, which was actually used for protecting contraception in 1965 and 1972. There were two cases. And so there was no right to abortion. It was created and basically based on a right to privacy that was also not based anywhere in law.
All right, thanks a lot. This other question, and I know that Arina, you went through various things that are necessary next steps for the pro-life movement. But one of our participants wants to know, what are the two most important things that we need to have in the pro-life movement, either on the local or national level? And Bill, I think that it'd be very good to hear your thoughts on this as well.
What are the most important things to have?
Two most important.
I'm sorry?
I think the top two is what they're asking for.
Top two most important. One, we need to continue passing pro-life laws in the states that still allow abortion, and also at the federal level. And that's another component that I think is necessary. There might be a federal bill on heartbeat, and that would affect all states. So we still need to focus on policy, and obviously, from what I was explaining, it's important for us to come alongside the women. That's the second most important thing. Come alongside the women through the pregnancy resource centers, through the resources that states provide. And that means that we all need to become activated. It's not just for us to do. The first portion is to continue doing it policy-wise, legislatively. The second portion is by people stepping up and helping to make sure that we create a pro-life culture in each state.
I mean, I think the one thing, rather than two, I would say the one thing is every single person needs to do something to contribute to building a culture of life. If you're a lawyer, you can do lawyer things. If you're a legislator, you can do legislative things. If you're a teacher, you can do teaching things. If you volunteer in a pregnancy resource center, you can do that. You can think of new things that now your state permits. As I said before, the key thing is you can never build a culture of life until you get rid of a national right to abortion. That's been done. Now it's up to every person, as John Paul II says in Evangelium Vitae, and you should read it again if you haven't. He goes through almost every artists do this, mothers do this, fathers do this. Everybody is called to do something. I mean, as long as abortion is seen as a solution to a problem, we'll have abortions. But the more we make a truly pro-life or culture of life in America, and the more, we take care of people who need help, like through our churches, and I know there are plenty of Catholic and other efforts to do this, but we need to expand them and we need to participate. No woman should ever feel like abortion is a solution to a problem. Any resources that she needs should be provided. If we have to suffer ourselves in terms of having less, then we have to do that. We have to sacrifice to build a culture of life, and every person can do something. Don't leave it up to somebody else.
Excellent. Thank you very much, Bill. Here's a question actually from Canada. This person's asking, will the Roe decision be challenged and overturned years from now after a fifth liberal justice is appointed to the Supreme Court? And yeah.
I mean, that could always happen. There's no doubt about it, which just goes back to emphasizing my first point of this whole webinar, which is the value of practical politics. If you either vote yourself or by not voting enable politicians to be elected who will appoint justices who think that abortion is a constitutional right, they will come in and overturn Dobbs. So as I said at the beginning, this is a great victory, but it's not a final victory. There are no final victories until the second coming. We're called upon to be actively engaged in sanctifying the world and responding to the needs of our brothers and sisters. So yes, that is a risk. And the only way to prevent it is to elect politicians who will appoint judges who have the right judicial philosophy. And I don't think, I think the right judicial philosophy is applying the Constitution as written, not as we wish it would be. Why do I say that? Because as I said at the beginning, that makes your vote count. If judges decide all these issues, you lose your vote. So originalism is the right judicial philosophy in a democracy.
Bill, I want to follow up on that question there. You know, you had mentioned the making judicial decisions based on what the Constitution says and not as we would like it to be. If memory serves, the Dobbs opinion talked a bit about how that was one of the weaknesses of Roe and Casey, of acting more like legislation that people would like to see rather than judicial decisions. So kind of tying that in to the last question, you know, are there specific characteristics of Roe and Casey besides unworkability that make them vulnerable to being overturned, which aren't shared by Dobbs? Like, are there certain elements that make Dobbs stronger, that make it less likely to be overturned than, say, these other cases, regardless of the makeup of the court?
Yeah, well, certainly that, I mean, it's a much more solid opinion, Dobbs is, because it looks at the history and tradition of the American people. Look, but if you get a justice on the court who rejects that, who thinks that their job is to unpack the meaning of the word liberty in the 14th Amendment in light of their own contemporary understandings of liberty, they're not going to be persuaded by what Dobbs said. I think Dobbs is extremely persuasive if you agree that the role of judges is to apply the Constitution. If you think the role of judges is to solve national controversies, which the Supreme Court said it did in Casey, then you're not going to be happy with the outcome in Dobbs. And I don't think we can escape that. And I think people have to think about it. And that's why I'm saying, as the court said in Dobbs, if you read Roe v. Wade, you might think, now I don't think pro-life people would think this, but you might think that's a pretty sensible resolution. You've got these trimesters, you've got these different interests. We balance one thing against another. Well, let's assume that was some kind of a sensible resolution. That's the job of legislature. That's not the job of the courts. That's what legislatures do. They have hearings, they have witnesses, they take evidence, they draft legislation. They have to advance it through negotiations with other legislators. They get it passed. Then the executive, if he vetoes it or she vetoes it, they've got to pass it over that veto or convince the executive to go along. So that's a legislative function to come up with the kind of supposed resolution that Roe did or that Casey said it did. Remember, Casey said that it had resolved this matter and that pro-life people should go home because the court, had resolved it. Well, the reason that was unpersuasive then, and the reason the court overturned it is not the court's job in a democracy to tell the people to go home. Now, the only way the court could tell them to go home was if the Constitution gives some particular power to the court, and it does not give the court this power to resolve disputes. It gives it very limited power. I mean, Justice Thomas would argue there is no right, there is likely to be no power by the court to find an implied right under any provision to anything. Although he says in his concurrence, it might be so under some provisions, but it's not so under due process. So my point is, if you don't let the judges rule you, it doesn't mean you can't, it doesn't mean the issues are gone. It means you have to rule yourself. But if you get a justice that thinks his job or her job is to tell you what liberty means based on what they think it is in 2022, then they're not going to be persuaded by Dobbs, although I think it's a great opinion.
Great, thanks a lot, Bill. Arina, this one came for you. You mentioned that making sanctuary. You mentioned making sanctuary cities within a pro-abortion state. Are there legal avenues for this, or is it simply a matter of supporting pro-life women's centers?
There are legal avenues for this. A mayor of a city, so there are actually templates for that kind of language, and I believe it's sanctuarycities.org, although I will have to go back to it. But there are at least 40 or 40 some sanctuary cities right now that within their city limits, they will not allow abortion. And so there are templates for how a city can do this. And I think that if we could just close in on the places where abortion's happening, as we have throughout the last 49 years, right? We had, there was abortion, and then we were able to pass laws, whether it's bans based on gestational limits or based on protecting the health and safety of women in abortion facilities. We started closing in on abortion in those ways. And I think that in a post-Roe America, we will now have to really hone in on the states that will allow abortion and see what kinds of laws we can continue to pass to protect women and children in those states, and as much as possible to make even those cities pro-life.
Great. Bill, you have anything to add to that? Nope. All right, Arina, here's another one. I think you might be able to answer on. And what do you see as the future for the abortion movement to, counter the strides made in Dobbs?
Well, we already see it happening, even in terms of what the current administration is trying to do, which is to provide abortions on federal property. We will see this from a federal level, the push for those types of things. As I mentioned, chemical abortions will continue to be pushed by Planned Parenthood and other abortion organizations. And, as Bill mentioned, even though Roe was overruled through the Dobbs decision, this doesn't mean that it can't change back. And so we have to continue to be on alert. Obviously, this current administration had also talked about adding more justices to the Supreme Court. And it's a problem when ideology gets in the way of the function of what our branches are supposed to do. And I'll just mention that having worked at Health and Human Services, in the executive branch, there can be abuses of powers in each of the branches. And I will say that currently we're facing threats in the form of regulations that will be coming out of Health and Human Services, especially on the abortion issue, on the gender identity issue. In the next, I would say in the next few weeks, we will see a regulation on Section 1557 that will come out that will try to force hospitals, including faith-based hospitals, including Catholic hospitals, to do abortions, to participate in transition surgeries, etc. There's also talk of a new regulation that will rescind the conscience protections that were passed by legislators, some of them decades ago, to protect the rights of conscience of healthcare workers from having to be involved in such objectionable services. And so the threats are in different ways, both from federal perspective, but also from the executive branch. And so we have to continue building a culture of life at every stage, as I mentioned, to come alongside women and children and families, and to build a culture of life from within. Christians were known for during the Roman time for saving babies that were exposed. So when they didn't want the babies, they put them in the woods or somewhere to be exposed and to die. And the Christians went and saved those babies. And we're called to do the same. We've been doing that, but we really will have to step up our game now that more babies will be born as a result of the Dobbs decision and Roe being overruled. And the fight will continue. And as Bill said, until the second coming, we will continue fighting, and we won't have that full final victory until then.
Bill, I want to bounce this one back over to you as well, but I also want to add another element to this question that one of the participants asked, was that they had heard on the news that one possible challenge is to find some right to abortion in the 13th Amendment. And can you comment on that at all?
Well, I would just again read the holding of the court. No such right is implicitly protected by any constitutional provision, end quote. So I have no doubt that pro-abortion people will make all kinds of arguments, but about other provisions of the Constitution, but the court has closed that door. And now, if the composition of the court changes, who knows? But I don't think that's, yes, pro-abortion people are going to make arguments, but this court has held there is no right to abortion at any place in the Constitution of the United States. And they said it as clear as a bell. So you're not going to come up with some clever theory that's going to convince this court they missed it. They said it. It's not there explicitly, and no such right is implicitly protected by any constitutional provision.
All right. This next question goes out a little bit to both of you. I think, Bill's legal background, I think, would be very helpful, but also, Arina's background working at the Office for Civil Rights is, someone asked, what do you make of the lawsuit in Florida claiming that their 15-week abortion ban violates the First Amendment for Jewish people who believe abortions must be performed under certain circumstances? How should the pro-life movement, which is often rested on the importance of the First Amendment, ensure that, what should the pro-life movement do, which has, since this movement has often relied on the importance of the First Amendment to ensure that providers aren't forced to perform abortions?
I'm not quite sure I understand that. When it says, what should the pro-life movement do? I mean, the pro-life movement does not support abortion under any circumstances for any reason. So it shouldn't change that view. If there's some argument about it, as I said before, about some restriction on abortion in a particular state, that's going to be subject to rational basis, which means as long as the legislature has a rational basis, it's going to be upheld. So I don't myself, although this is the first time I've heard mention of this case, I don't see that it has much chance of success.
And I will add to that, that pro-abortion groups have been trying to use a religious argument for protecting abortion as well, especially Satanists that see some abortion as part of their belief system. So, but that doesn't hold. And again, there's no right to abortion in the Constitution. And the argument that the killing of someone is part of your belief will not hold in court. But I think that they're trying to find creative ways to continue to push for abortion, sometimes using these inverted arguments. Obviously, with conscience protections and the federal conscience laws in the books, legislatively speaking, it's these conscience laws are put in place, and actually were put in place when some of them were put in place when Roe became the law of the land, to protect the rights of medical doctors from having to do abortions, etc. But and some of these are not, the conscience protections are not all based on religious reasons. Some of them are just people with no religion at all that have objections. But I think that the pro-abortion movement is trying to twist those arguments for where there are sincere religious objections, and try to protect abortion through those, and people can see that that those are, a twisting of an argument.
All right, thanks a lot. Last question, and this one's going to go to you, Arina, and Bill, if you want to chime in, of course, feel free. But one of the participants is a nurse in New Mexico, and has said that the state has recently taken away the conscience protection of healthcare workers. So what avenues do healthcare workers have to protect their right to refuse to participate in abortion, assisted suicide, and contraception or morning after pill?
Well, thanks for that question. This is a troubling trend, and we will see more of this. So having worked at the Office for Civil Rights, they have a way for you to file a complaint. Now, sadly, under this administration, I'm not sure that complaint will be investigated, but it is important for people whose rights of conscience have been violated to continue to file complaints, because those become part of the record in the Office for Civil Rights. And presumably under a different administration, those complaints will be investigated. So that's more on a formal side. So if you go to hhs.gov/OCR, you will see a way to file conscience complaints. But I would definitely contact the Christian Medical and Dental Association and the Catholic Medical Association as well, and let them know about your conscience rights being violated. They have a number of these cases and it's important for them to know about it as well. And they will also be able to provide resources for you. I think that at the state level, whenever possible, you should consider testifying when different bills like this come up, because the voice of, especially of a medical professional who is being affected by a bill, or who would be affected by a bill or a law, is extremely moving, because it's not just theoretical. And if you need help with training to testify, there are many resources. There are organizations that are helping with training for doing such testimonies. So I would encourage you to just get in touch with me, and I can put you in touch with them if you just don't have the resources. But there are ways to speak out against it. Obviously, you can also, if you wanted to go public with it, You can write op-eds, but also contact one of the legal organizations, Alliance Defending Freedom, First Liberty, and other groups that will potentially take your case and file lawsuits against it. So there are many ways that you can fight back, and we need to, because this is a threat that is coming.